Namaste. I'm Swarna. Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from Law Office of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Thursday at 5 p.m. EST with attorney Ms. Chand Parvatini Garu and Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English and on Friday at 6 p.m. EST with Banu Ilendra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or you can call us at 866-725-7441. Before we begin the show, please note the information provided on the show is not a legal advice. It's for general information purposes only. Sakshi TV or its agents will not be responsible for this information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction, but if you need consultant, please log on to www.reddyesq.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hand of the immigrant community and for the benefit of US employees. The www.reddyesq.com site provides you with the last and cutting edge information of US immigration law and policies. Explained in terms you do not need to have any lawyer to explain you. It is easy for you to understand. We are going to discuss about Perm Audit triggers. Before we get into this topic, you can call us on the number on the screen for questions related to immigration and also ask for tips. So, hello, Ms. Prashanthi.
Hello, Andy. How are you?
I'm good. Thank you. How are you?
I'm good.
Awesome. So, before we get on to the topic, do you have any latest immigration updates this week?
So, let's go directly to the topic as we have a lot to cover. So, no updates.
No updates. Okay. So, Ms. Prashanthi, can you explain us about supervised recruitment triggers of 2023?
Sure. So, we will get to the audit triggers, but also what we're going to discuss is a few do's and don'ts for filing perm. And we did go through them. This is actually part 2, audit triggers. We did part of it last week. And so there are a few more topics that we have to cover on the topic. And then to conclude, we will go to and discuss some of the perm triggers. And then if we have time, we will go through some of the frequently asked questions for perm. So one thing I wanted to discuss, wanted to start off with layoffs. Now, we know that there have been a lot of layoffs taking place recently, especially in the IT sector. That's been in the news everywhere, H-1B candidates being laid off from all these big companies. So what is the effect? I mean, we have in the past talked about what the effect of layoffs are on a person's status, on if they're on a H1, say if they're on an F1. But today we will talk about what the repercussions are if the person is filing a perm or a labor certification, what the repercussions of a layoff are if there have been layoffs in that company who's filing the perm for them. So there are a few questions in the form itself. So when you're filling out the 9089 form, there are questions about layoffs. So the questions are, have there been layoffs? And the other question that is, did the layoffs occur within the past 6 months? Were the former employees US workers? These are the questions first that we have to ask ourselves to see whether this affects our perm application or not. So have there been layoffs? Did the layoffs occur within the last 6 months? Of course, this does not extend to people who are terminated for cause. So for example, if a person is terminated for bad behavior or non-performance, then that is not a layoff, just to distinguish between the two. So were the former employees, whoever was laid off, were they US workers or permanent residents, or what is their status? Were the former employees laid off in the area of intended employment, meaning a labor certification is filed for a work location, say, and the work location is a specific state, then you have to ask whether the layoff occurred in that same work location. And also say that there's no work location, say you're filing for unanticipated work sites because you don't know where you're going to be placing your employee. They can be working at different client sites in different states. So then if that's the case, so if that person who was laid off is also at different unanticipated work sites, then, that's something to consider. Another question is where the former employee is working in the occupation that we are filing the perm for. So if you're filing as a software engineer, was the former employee who laid off also a software engineer? Another consideration is if the former employee was working maybe in a related occupation. So if it's a related occupation, then it's also something that we must consider. So if for any of these questions, if the response was yes, then with reference to have there been any layoffs, you have to answer yes in the 1989. So related occupations, I just wanted to touch upon that a little more. So when we file a perm, we could say that we require a job only in that specific occupation, or we could say that any reasonably related occupation is acceptable. So especially when that is the case, you definitely have to look at any layoffs in related occupations as well. But even if that's not the case, and you're saying you are looking for candidates only with that particular experience, and you're not accepting people with related experience, you still have to look at a related occupation. And if the majority of the duties are pretty much the same as the duties that you've put on the perm, then you should still consider that as a yes. So if it is a yes, and if the employer has laid off people within the last 6 months, within the geographic area, within the same job, then when you answer yes, what are your obligations? Can you then continue to file the perm? That's the question. The answer is yes, you can. But you must notify all those laid off employees, the qualified laid off employees, that there is this job available, and you should invite them to apply for the job. Now, if those laid off employees are permanent residents or US citizens, then, and if they apply for the job and if they qualify, then you cannot proceed with your labor certification. You can proceed if you're willing to hire the laid off employee as well as, continue with the green card for your present employee. But if you're not willing to hire the laid off employee, then you can't proceed. This way, if you're willing to hire, you can say, yeah, I'm hiring him and I still want to continue this perm process because, we have more than one position available anyway, right? So something to consider. So any former employee, must be evaluated to see if that individual is able, willing, or qualified to perform the job. So based on that analysis, you can also do technical interview. And based on that technical interview, if you find that the person has the educational qualifications, the experience, the skill sets, because we do put in some special skill sets. So if they have all that, then you have to presume that they qualify for the job, and then you have to either hire them or you have to stop the processing of this labor certification or perm that you're filing. There's some other advice that I can give you on perm filings in case of layoff situations. Something we have to remember is the perm process is an attestation-based process. So to a certain degree, this whole process relies upon the honesty of the employer, right? So however, any employer may be tempted to be less than forthright in any manner. They might want to tell lies about it. It's important to reiterate that filing the labor certification, the employer is attesting, they're signing and they're attesting that all the information contained within the 9089 form is true and accurate to the best of their knowledge under penalty of perjury. So if you can't commit perjury, it's actually a criminal offense. So please don't lie on this application. If it's a yes within all the parameters that we discussed, make sure you say yes and then deal with the problem after that. Because there are a lot of penalties when you fail to abide by this penalty of perjury, and there's significant fines as well as, up to a 5-year jail sentence, etc., etc. So even though it's an honor-based system where you're just giving yes or no to the question, you're answering yes or no, they might, if they find out, and they might in an audit look into things more in depth and ask for documentation in that situation. And audits are random. You never know who will be audited and who won't be, right? So always be careful. Also, an employer must maintain documentation showing that you're complying with these requirements, right? That you have actually notified these laid off US workers. So such evidence includes letters, emails, phone calls, or any contemporaneous documents showing that a notice was provided to any interested former employee and they were properly considered for the job opening. So if you have had an interview, then you should record the interview as to what were the questions and what were the answers. You have to prepare a recruitment report, which basically has this information as to when you contacted them, what time, by email or phone, and if were not able to contact them by those means, then you're supposed to send certified mail receipts. You're supposed to send a notification by certified mail return receipt. So all that proof you should keep, and if there is an audit, they will ask for all that proof. So if the former employees, for example, declines to receive such notifications or asks that you discontinue sending them emails, then you should, or they decline the position, then the employer must retain proof of those communications as well, right? So just a tip to keep in mind. Even if there's no audit, we always expect an audit and prepare our documentation in that way. Now, let's go to the audit triggers. I have a few triggers, a few situations in which you are more likely to get an audit. First one is audit trigger number 1, applications where the job requires a master's or a bachelor's degree but no work experience. So especially for senior positions, if you just say master's degree required or bachelor's degree required and no experience, you might get an audit for that, because the Department of Labor, first of all, it's not believable that the job can have a requirement where there's no experience unless it's an entry-level job. And second, the Labor Department doesn't want to believe that you receive no applicants for a bachelor's or a master's in computer science, because they know that there is availability of those people in this country. On the other hand, if you put in 2 years of experience and you put in skills, etc., etc., then there's a likelihood that, even if you say no resumes, or if you have not received resumes, that is more believable. So those are the reasons why you might get an audit if you say no experience. Applications where the job requires less than a bachelor's degree. So audit trigger number 2, where you are requiring, say, 3 years of experience for a computer science professional, depending, of course, on the position. But if it's a professional position, where the industry usually requires a bachelor's degree, say, again, a software engineer, and you simply say that 3 years of experience required, and you say that you haven't received any resumes, again, it's likely to, there's likely to be an audit. I mean, may not be or maybe, but more likely than if you didn't mention that, if you mentioned a bachelor's degree, right? So more likely than not. Audit trigger number 3. Applications where employers have indicated having a layoff in the area of intended employment. And for the position involved and within the last 6 months. This is what we were talking about just now about layoffs. So if you say that you've had a layoff recently, then it's more likely that you will get an audit, and they might ask for additional information with reference to the layoff and with reference to in an audit they always ask for recruitment information. So they'll ask for copies of your advertisements. They will ask for a recruitment report, which will basically say how many resumes you've received, or if you have not received any resumes, it will say. So how many resumes you've received? What was the result of those resumes? Did you conduct interviews? What were the questions asked? What were the answers? Proof that you've reached out to those applicants. So these are all the questions that they ask. They also they might ask some other questions such as, information about the company. They might ask whether there's any relationship between the applicant that you're filing for and your company and or the owner of the company, whether if they're immediate relatives or they know each other. That happens sometimes, especially if you have a common last name. I've seen that question as well come up in the audit. So audit trigger number 4. Applications with requirements that are not normal for the occupation. That is overstating the requirements. So we've seen understating, where audit trigger number 2, where we've said less than a bachelor's degree for a position that usually requires a bachelor's degree. But some people will draft the job in such a way that they will ask for, say, bachelor's plus 10 years of experience for a software engineer position. While that may not be an unusual requirement in the industry, what you need to look at is what the DOL says is normal or not normal. So they think they know everything about industry standards, unfortunately. So they have a system. They have a numbering system called the Specific Vocational Preparation, SVP. So they assign every job an SVP number. So they say if it's an SVP of 7, then you can't require more than bachelor's plus 2 years. If it's an SVP of 8, then you can require bachelor's plus 5 or a master's plus 3 years of experience. So if you're asking for 10 years of experience, really there are very few jobs as per them that qualify for that amount of experience. So when you do that, usually you might get an audit. It's not that if you get an audit, the case will get denied. That's not the case. It's just that they're asking for more information. It's like an RFE, a request for further evidence. So during the course of that audit, you might have to explain why you require 10 years of experience for this particular job. And maybe you can show related occupations, advertisements from other companies that show that they also required 10 years of experience for the job, or letters from other companies saying that for this particular job, it is so complex and a lot of experience is required, and giving the reason behind it and saying that it's common in the industry to require it. Maybe you can explain the complexity of the job in a business necessity letter. Maybe you can explain the nature of your business and say why in your business it's required, when maybe other businesses it's not. So there are many ways of overcoming this, but overstating the requirements is definitely an audit trigger to keep in mind. So audit trigger number 5. Is there a familial relationship between the employer and the employee? We were discussing that as one of the audit triggers. So the reason why this could be an audit trigger is because then they will not believe that there is a bona fide job offer, or they want more information to make sure that there's a bona fide job offer, because there is a blood relationship or a family relationship between the employer and the employee. Say you're filing it for your spouse or your brother or your, something like that. So a child. So it always, the employer-employee relationship and bona fide offer of job employment always becomes an issue in such cases. And as I said, sometimes even if there's no relationship, they will send an audit if the employer or the signator and the employee share the same last name. So that's also something to keep in mind. Audit trigger number 6, I believe. Yeah. Where the foreign worker is one of a small number of employees. So what it means here is that you are a small company, or maybe you're a large company, but you have very few employees. So if you have less than 10, say, or less than 5 employees, you're more likely to get an audit when compared to, a big company with hundreds of employees. So the size of the company also could trigger an audit, because they want to make sure that you actually have a requirement for this person. And sometimes they even ask for documentation like they do in a H1. They ask for contracts and work orders, and when they're not supposed to actually be asking for that, because this is really an offer of future employment, the green card. The employer is basically saying that we are going to hire them. Once they get the green card, we have an offer. So I guess they want to see what is the potential that your company has and what requirements they have, etc., etc. Again, this is to prove that there is a bona fide job offer. The last audit trigger is where the employer is a closely held corporation or partnership in which the foreign worker has an ownership interest. So say you have 2 partners in the company, and one of the partner is filing a green card for himself. That could be an audit trigger as well, because again, the bona fide nature of the job is questioned, whether there is an employee-employer relationship, whether you have actually a job offer for this person. This is not an issue in some instances. For example, if you're filing an L1 or you're filing an I-140 or a green card based on an L1, that's not an issue because you can be an employer and employee at the same time. But with reference to a labor certification, that unfortunately becomes an issue because you have to show employer-employee relationship. So with that, we are done with the audit trigger part of the section. So we can go with the frequently asked questions now, if we have any.
Yeah, definitely. Thank you, Ms. Prashanthi. So we have actually received like a few questions, and I would like to ask you, the first question will be like, will PERM be denied if my employer is a startup or non-profit organization?
So if your employer is presently non-profit, or say earning very little revenue because they are a startup, you can still file a PERM. So, but however, at the time of filing the second step, which is the I-140, you have to demonstrate that your employer has the ability to pay you the prevailing wage that you mentioned on the PERM. So that ability to pay could be shown either through your tax return to show that you have profits equivalent to the prevailing wage, or even better, if the employee is already working for you, then you simply have to show the W-2. And if that amount meets the prevailing wage amount, fine. If it doesn't, then you can show a combination of the W-2 and your profits and add both amounts, and that should be equivalent to the prevailing wage. So there are a couple of ways that you can do it, but yes, you can definitely do that, even if you're a startup or a nonprofit.
Okay. So what about like if employers goes out of the business? So will that leads to the denial of the PERM?
Yes, unfortunately, if your employer goes out of business, then the best thing to do is to find another employer, because even if the PERM is approved, say somehow the PERM gets approved because there's no audit and no one notices that your employer went out of business. But after that, you'll have to go to the next step, which is the I-140, because the PERM by itself won't help you get a green card. It may help you for some purposes, to get an extension on your H1 in some situations. but won't ultimately help you get a green card. So the next step, which is the I-140, it will not be possible to file it because the person has gone out of business. You'll have to, unfortunately, you cannot use that existing perm and file an I-140 through a new company. You'll have to restart the entire perm process.
Okay. So does that mean like leaving the country also will affect the processing approval date of the perm?
So fortunately, leaving the country doesn't, or traveling abroad doesn't affect your perm process at all.
Okay.
So the only thing you need to re-enter is a valid visa. If you have a valid visa, you can absolutely re-enter the country. And also your perm is not affected by leaving the country. In some situations, immigration status does get affected. For example, if you filed a 485 for a family-based petition and you leave the country without without getting an advance parole, that could lead to denial of your green card, your 485. Another instance is if you file a change of status from one status to another, and if you leave the country, then your change of status can get denied. But with reference to the perm, there are no serious complications with reference to traveling when the perm is pending. It doesn't affect your perm process.
Awesome. Thank you so much, Ms. Prashanthi, for your time and providing all the information. But unfortunately, we are running out of time for this week. But thank you so much.
Thank you. Thank you. It was a pleasure to be on the show.
Thank you so much. This is Varna signing off. You're watching Telugu Prajala Sakshi TV. Namaste.